A patent is a complicated and tedious process. It can often take 2 years or more from the time a patent application is filed until a patent actually is issued in the U.S. In the United States, patent applications are filed in the U.S. Patent and Trademark Office, which is a division of the Commerce Department of the federal government. After a patent application is filed, it is assigned to a particular technology class and subclass and given to a patent examiner having a technical background corresponding to the technology class of the patent application. The patent examiner does a search for existing patents or printed publications that relate to the technology claimed in the patent application. And typically, the first substantive correspondence, called an official action from the U.S. Patent Office, is a rejection of the application. The first official action is usually received between 6 and 18 months from when the patent application is filed. The patent applicant is given the opportunity to respond to the official action by amending the scope of what is claimed in the patent application or by arguing that the examiner's rejection is inappropriate. If the applicant's response is successful, a notice of allowance is issued by the patent examiner. And after the applicant pays a government-mandated issue fee, the patent is issued. Let's look now at copyrights. Unlike patents, copyrights are meant to protect the creative, original, non-functional aspects of a product. In the United States, copyright rights vest as soon as the writer or artist fixes the work in a tangible medium. Rights are not lost by failing to file a copyright application, and a copyright registration does not have to be obtained for the author to have copyright rights. In other words, as soon as the poem is written onto a piece of paper, as soon as the painting is painted, or as soon as the computer program is saved onto a hard drive of a computer, the author has protectable copyrights. Literary works, computer programs, music, including the sound recordings or the words, dramatic or choreographic works, art, films, and even architectural works can be protected by copyright law. Ideas alone, specific facts, and purely useful items cannot be copyright protected. Copyrights only protect against unauthorized copying of the work. Copyrights do not protect against independent creation by another. Neither do copyrights protect the functional aspects of a work. For example, the actual lines of computer code in a software program can be copyright protected, but the way the software program functions or operates cannot be protected. In fact, it is perfectly permissible to reverse engineer a piece of computer software without violating the copyright of the author of the software. Even though a copyright registration is not required, there are very distinct advantages in obtaining one. For example, copyright damages will not begin to accrue until a copyright registration is issued. Additionally, a copyright registration is a requirement for bringing a copyright lawsuit in federal court in the United States. Copyright applications are relatively easy compared to patent applications. A copyright application can be filed by filling out the proper forms, which are provided on the Copyright Office website, and providing a sample or copy of the copyrighted work with the application. Turning now to trademarks. Trademarks protect the goodwill associated with a business by protecting product brand names. Trademarks do not protect the underlying product, but only the brand name of the product, and only for a particular product category. It is possible, and even not unusual, for two companies to use the same trademark, but on different categories of products. For example, there's a Domino's Sugar and a Domino's Pizza made by different, unrelated companies. Trademarks can come in many different shapes and sizes. Words, logos, symbols, slogans, musical jingles, fragrances, colors, and even product package designs and product shapes can function as trademarks. For example, the word Coke, as well as the curvy shape of the bottle that holds the cola beverage, are trademarks. The color pink for Owens Corning fiberglass insulation is a trademark, and so are the well-known NBC chimes. There are four main types of trademarks: trademarks, service marks, collective marks, and certification marks. Trademarks are marks used to identify the source of goods, as opposed to service marks, which identify the source of a service. Collective marks are marks that signify membership in a group, such as Boy Scouts of America. Finally, certification marks signify that a product or service meets the standards of the mark owner. An example of a certification mark is the Good Housekeeping Seal of Approval. The main policy behind trademark law is the protection of consumers from source confusion. Thus, in order for there to be trademark infringement, there must be a likelihood that consumers will be confused by use of a mark. A multi-factor balancing test is used to determine the likelihood of confusion. Some of the factors considered are similarity of the marks, relatedness of the goods, the distribution channel of the products, the sophistication of the consumers, the strength of the mark, and whether there is proof of actual confusion. Famous trademarks enjoyed additional protection from dilution. Dilution does not require a finding of likelihood of confusion. Instead, dilution protects against association of the mark with a product of lower quality or the product that creates unpleasant feelings in the public about the product. For example, it is unlikely that a consumer would believe cigarettes or whiskey labeled with the Disney mark are actually produced or endorsed by the Walt Disney Company. Nevertheless, the association of these types of adult products with the Disney mark no doubt dilutes the mark's value. Thus, it is not hard to imagine a situation in which trademark dilution would protect the owner of a famous trademark, but traditional trademark infringement would not. Public association between the mark and the product is the cornerstone of trademark protection. Trademark rights are acquired by using the mark on goods or with services. Similar to copyrights, a trademark registration is not necessary to secure rights, although it does provide additional benefits beyond those acquired by simply using the mark. Rights based only on the use of a trademark are called common law rights. In order to qualify for the additional benefits associated with a trademark registration, the mark must be used in interstate or international commerce. It is possible to file a trademark application before actually using the mark, but actual use is required in order to obtain a registration. Intent-to-use applications, as they are called, provide rights dating back to the application filing date. Use-based applications and common law rights provide rights dating back to the first use of the trademark. Common law rights to a trademark are limited to the geographic region or area in which the trademark is used, such as Southern California or the southwestern United States. A trademark registration provides national protection, even if the trademark is only used in a limited geographic region. The increasingly widespread use of electronic media and the development of e-commerce has led to the development of a number of new IP laws in the areas of patents, copyrights, and trademarks. For example, the United States recently enacted the Anti-Cybersquatting Consumer Protection Act, or ACPA. This new law defines a new standard of illegal conduct in applying trademark law to Internet domain names. The ACPA prohibits the bad faith registration of Internet domain names that correspond to another's trademark. One unique aspect to the ACPA is that it provides for statutory damages. Traditional trademark law requires that damages be proved, such as by showing that profits were lost due to the trademark infringement. Under the ACPA, the trademark owner can elect statutory damages as an alternative. If the trademark owner does so, he or she is not required to prove damages, but is entitled to an automatic minimum of $1,000 or maximum of $100,000 in damages. Trademark rights can be lost by improper use of a trademark by the trademark owner. For example, improperly using the trademark as a generic name for a product instead of a brand name identifying the source of the product will result in a loss of trademark rights. Products such as linoleum, aspirin, escalator, cellophane, kerosene, mimeograph, trampoline, shredded wheat, and dry ice were originally trademarks, which were improperly used and thereby became the unprotected generic terms for those products. Once a trademark becomes generic, anyone can use it. In order to avoid having a trademark become generic, the trademark owner should follow a few basic rules. Trademarks should always be used as proper adjectives, followed by the generic name of the product. For example, Kleenex tissues, Pampers diapers, or Lifesavers candy. Also, trademarks should never be pluralized or used in the possessive form unless the trademark itself is possessive. Finally, trademarks are never verbs. It's okay to say, make 6 copies on the Xerox copier, but you should never say, Xerox this report. Finally, turning to trade secret law. Trade secret law provides protection for confidential information that provides the owner with an advantage by virtue of the confidential nature of the information. There's no way to register a trade secret. A trade secret is protected as long as it remains a secret. Once the secret becomes known, trade secret rights are lost forever. Thus, the trade secret owner must vigilantly protect the secrecy of a trade secret by putting internal processes in place to limit employee access to the information and to guarantee the information does not become known outside the company. Trade secret protection results from the law's recognition of the right to be protected against the breach of duty arising out of a special relationship of confidence, such that disclosure of the trade secret is an unlawful act. Because trade secrets are only protectable from wrongful disclosure or misappropriation, they do not necessarily give the owner the right to exclude others. There is generally no protection against honest, lawful discovery of trade secret information by others, such as through reverse engineering. Trade secret protection is primarily used to protect a process that can be confined within a factory. A product, such as a recliner mechanism, can be seen by others and reverse engineered once the product is introduced into the marketplace. One of the most famous and closely guarded trade secrets is the formula for Coca-Cola. Other types of trade secret information can include customer lists, processes, and techniques. In conclusion, intellectual property has become an essential business asset in the new economy. For those who ask why, the simple answer is given by 1930s era bank robber Willie Sutton when asked why he robbed banks. It's because that's where the money is. As economist Lester Thoreau puts it, skills and knowledge have become the only source of sustainable long-term competitive advantage. How these skills and knowledge are configured and deployed will dramatically shape competitive outcomes and the commercial success of an enterprise today. In fact, most new economy companies' very survival depends upon it. Thank you.
We're now ready to begin the first question and answer session. We will try to answer as many questions as possible. Therefore, we ask that only one question be asked per phone call, please, and that these questions be as brief as possible. You may call the studio directly at the phone numbers or the fax which appear on your screen. We remind you to make your phone calls at a distance from the monitor to avoid feedback. And our first question today comes to us from our neighbor city in Tijuana. It comes to us from the Centro Universitario de Tijuana, and the question is...
Good morning. The question is the following. Apart from strengthening ethical values, in what other way can we stimulate and motivate university students to consult research papers that have to do with intellectual property through the network without being tempted to plagiarize and to appropriate themselves of that material?
Okay, a really interesting question for us. How can we stimulate and motivate ethical behavior on the part of our students to recognize the intellectual property of the work that they use in their own classes? Lowell, do you want to start with that? After 30 years being in a college classroom, I'm sure that question has come to your mind many times.
Well, it certainly has, and I don't have a general answer to the question. You have to impress upon the students that you're working with the importance of original contributions on their part. It's part of the learning process. So I don't think there's an overall way that you can guard against that. Students will always be tempted to plagiarize work, especially if it's easily available to them and if they're unlikely to get caught. All you're going to do is appeal to their better interests and let them know how important ethical behavior is.
Mm-hmm. You know, Peter, I would suspect that the stakes for this question get raised a little bit more when you're dealing with law students. I mean, it's one thing to plagiarize, on a paper. It's another thing to plagiarize in the practice of law. Do you do anything special in instruction to impress that?
I don't really think that there's anything special about law students. I think they're confronted with some of the same issues. I do agree that the stakes are raised, especially since it's very likely that a student, if they're caught plagiarizing a paper in a law school class, could very likely be excluded from ever practicing law due to the ethical requirements that most state bar associations have.
It also seems to me that students have a lot of confusion over plagiarism and over legitimate and honest efforts to seek help. I know just yesterday in my freshman seminar class, I was talking to the students about whether or not it was okay to get editing help on a paper. And they weren't all clear on that, as to what was okay. Can you help us to sort out the difference between editing help versus plagiarism, idea generation versus editing?
Well, drawing ideas from different sources and synthesizing them is a very important part of the educational process. But to use material unchanged without attribution is clearly, that's the definition of plagiarization. So.
But I'm wondering how we might get students to understand that, if you have any good strategies on how we, I mean, the question here is asking us how we motivate our students to do that. I'm wondering if some actual discussion of the topic with students is a motivating factor, and if we can somehow get them more excited about the creation process and teach them that it's okay to borrow, it's just not okay to steal.
Well, if you ignore it, they'll assume that it's not important. So it should be addressed in class.
And I think you can point out that most of the great discoveries in the world result from sort of borrowed ideas. And you're right, it is okay to borrow, and as long as you add something to what you've borrowed, and as long as you attribute what you've borrowed to the actual source.
Okay. Thank you very much for that. We have another question that has come in from Mexico, from the Universidad de Salé, and they want to know how it is that you determine whether or not to apply for a patent. How do you determine that?
Well,
Peter?
That's a very interesting and difficult question to answer. The value of a patent is in its right to exclude others from using or making or selling products that embody that invention. And so if you're looking to make an economic determination on whether or not you should apply for a patent on an invention, you have to consider that the patent that would result from a patent application is only as valuable as the right to exclude others from using this invention. If it would be easy to create products and sort of design around that invention, if it would be easy and inexpensive to do so, then the patent isn't very valuable because, as I said, the patent value derives from its right to exclude someone from practicing that invention. The other thing I think that you have to consider is the cost of applying for a patent. Patent applications are generally very expensive to prepare and file, and the patent office is slow in issuing patents, sometimes 2 to 3 years from the time that the application is actually filed. And in many quick-moving technologies, no patent actually issues before the technology life cycle has ended. If there's a year or 2 year turnaround on technology in this sort of area, then filing a patent application on this technology, unless it can result in very broad claims, probably isn't very valuable.
Okay. Our next question comes to us from Mexico, and it comes to us from the Instituto Politécnico Nacional, and I suspect that we may have another question along these lines.
Buenos días. Mire, la pregunta es la que sigue. ¿Cómo se enfoca
How
la
do
ley
you
de propiedad intelectual
focus, how do you look at the law of property rights if we have all the space research? And the other question is, how much money do you have to pay to obtain an intellectual property right? And do you have to, what happens if you want to register it with the IPO?
Okay, we have a number of questions here that are very pragmatic. How much does an intellectual property right cost? I think maybe they're talking about a patent or a trademark. What happens if you want to register it with the worldwide IPO? And I think it's really kind of more of a follow-up here, too, in terms of how do you go about the process of applying for a patent? Yeah.
Well,
Lowell,
yeah, to follow up, to try to answer the first part of this question and then to follow up on the previous question. Every time you or an employee have an invention, anytime you come up with an invention or something that's new that you believe is patentable, in our company we require each of our employees to prepare an intellectual property disclosure, signed, dated, registered with our IP attorney. And then we have periodic reviews by an intellectual property committee. At any given time, we'll have between 100 and 200 intellectual property disclosures that are pending. And the intellectual property committee has to look at each of these disclosures and determine, number one, whether to file a patent, number two, whether to keep the invention as a trade secret, or number three, whether to publicly disclose the information. And that's a very important first decision that we have to make.
Okay. We have another question here coming from Mexico, from the Universidad Tecnológica de Tecamachaco, in Mexico. And that question is?
Our question is the following. Could you give us an explanation, a deeper explanation about the concept that you used about engineering, inverse engineering? Could you give us some examples as far as that?
Okay. Peter, I think this one is to you because you talked about the concept of reverse engineering, and they'd like a couple more examples of that to understand what you mean by that and why that would not perhaps violate a trade secret.
Well, reverse engineering, the concept of reverse engineering has to do with figuring out how an invention works. For example, if you're using, if you've purchased a reclining chair, and the reclining chair has a certain mechanical mechanism for allowing a footrest to come out and for the back of the chair to come back, it's possible, if that meets the other requirements of patentability, to actually patent that mechanical device that allows the chair to recline. If you don't patent that device and you try to protect it with a trade secret, it's likely and relatively easy for someone to go in, examine that mechanical device, figure out how it works. That's an example of reverse engineering. If they figure out how that mechanical device works and it's not protected by a patent but only protected by a trade secret, they're allowed, the person who has sort of reverse engineered that or figured out how that mechanism works is allowed to manufacture chairs that include that mechanism, because once they figure out how it works, it's no longer a secret.
Okay. We have another question coming to us from Mexico, and this one is coming to us from the Comisión Federal de Electricidad, and we'll hear their question now.
Mire, habla el ingeniero Rolando Cerrato de la Vega,
Engineer Rolando from the Federal District of Mexico. I want to thank you very much for this 101 transmissions and broadcasts of this program, the series of video conferences. We want to congratulate everyone. And here's our question. If an invention comes from a government office, does this belong to public domain, or how can we consider this?
Okay, a very interesting question. And thank you very much for your congratulations. It's truly our pleasure to be able to bring this to all of these sites. The question is about a government office, and how does this apply? Lowell?
Well, actually, our company licenses technology that was developed by the U.S. government. In the past, government laboratory employees were encouraged to publish their work in various ways, but now they're encouraged to patent their work and license it to commercial companies for the public good. And so some of the key technologies that we've developed have come from these sources.
Okay, very interesting. So we've seen a change in how the government responds here in this country. Do you have another comment on that?
Well, actually, just to follow up on a previous question, there was a question about patent costs. And I don't have a general answer. I know that in our firm, for U.S. rights only, we budget on the order of $10,000 for a U.S. patent. And we budget on the order of $50,000 for worldwide rights.
Excellent. I'm sure that's helpful. Thank you. We have another question now coming to us from Argentina. So welcome, Buenos Aires.
Buenos días, aquí estamos en el grupo previsional de la Nación y tenemos.
We are here together at the premises of La Nación. We have two questions. One of those is related to the knowledge of the limited use of a certain software that enabled people to record music, and that way was going against the property rights of the editors and publishers of music. And we want to know if there are some other rulings with regard to intellectual property apart from that one related to Internet applications and use over the Internet.
Okay. I think we've got a question that's right in the center of what it is that Peter does, and it's certainly been a very, very hot topic in the United States. I have a 18-year-old, and she follows this with a great deal of interest. What are some of the rulings here on the use of the Internet and distribution of intellectual property?
These rulings actually go back quite a long time, and it's not the first time that courts have addressed this issue of devices that make it easy to copy music or video recordings. Some of the earliest rulings that courts made with respect to this sort of technology had to do with the Sony Betamax video recorders. And early on, when a court addressed those issues, they determined there is, under copyright law at least, which is the type of law that would apply to most of this stuff, music and video recordings, there is a fair use defense. And in the Sony Betamax case, the court determined that it is a fair use for somebody to record a television program, at their home so that they can watch it at a later time. There are all kinds of requirements that have to be met in order to qualify for a fair use defense, and the most important of which probably is that this fair use has to be non-commercial in nature.